And
She
so
in custody?
she is, yes, Your Honor. And she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000.
Provided.
Yeah.
Okay.
It must have just gotten set. I don't know.
Okay, is it a PER bond?
No. It's a
Okay.
short.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigoin, do you need a translator?
No.
Do you mind me bringing up Ms. Gill? All right. Good morning, Ms. Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FSGI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The complainant...
So are you telling me now it was intentional?
Sure. The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck the vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Colored.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
Judge, after.
Finish.
I'm so sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss
Right away, the judge spots a problem that changes the entire tone of this hearing. Officers say this man interfered with a capital murder operation, but the facts are getting messy fast. Was the suspect in the truck? In the house? Was the perimeter even clearly established? In probable cause hearings, details matter, because if the timeline falls apart, the charge can too. And you can already hear the judge thinking, something here isn't adding up.
With the attitude.
Okay.
Truly,
Okay.
in this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public. And your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, really.
don't say anything.
How many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping me. I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay, I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay, and I'm tired of this. I'm tired of all of this, okay, in front of my children. My children have trauma, okay, and I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it. on a daily basis, ma'am. I don't care who it is. I don't care what color. They're small.
This is one of those courtroom moments people overlook. The judge dismisses probable cause, but then immediately gives a warning anyway. Don't get into a power struggle with police. That's the uncomfortable reality of these encounters. Even when the legal case is weak, the physical consequences can still be very real. Question for you guys. Should citizens always comply first and fight it later in court? Or are there situations where standing your ground makes sense?
Farm animal. I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes. Really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm going to do. I'm going to leave your bond at $1,000 now. All right. I'm not going to raise it to $5,000, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. That's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case.
sir. Yes, sir.
And just, all right. Come on. Justin.
Look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Justin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. Sir. Can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for
I go to sleep early.
Test, and he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Ankemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No,
Oh my God.
Your Honor, may we discuss setting a new bond further?
of course.
Oh my gosh. Why? Please, I'm trying to do everything.
Goes with you.
Wow, the courtroom energy just completely shifted. What started as a traffic-related case is now turning into a public safety debate. The judge isn't only reacting to the allegations, he's reacting to what he sees as attitude, recklessness, and escalation. And notice how the CDL revelation actually makes things worse in the judge's eyes. Commercial drivers are held to a higher standard because they're trusted with massive responsibility on public roads.
The bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But fine. Because
email from
if anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also,
You went the day before court.
and I also went before.
Judge, she's been going before even the last court date, and we
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to class. So she's been going, she did already take the test, and this is the one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
But I'm trying to text you.
Texting who?
The instructor, like what I'm supposed to show you. Because I don't have no proof, like I don't have nothing.
Tell me what have you done?
I went to the class,
Okay. Which class did you go
the
to?
GED resource.
Okay. And because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but
This exchange is intense because both sides feel unheard. The defendant is talking about trauma, mental health, discrimination, medication struggles, while the judge keeps steering back to accountability and danger to the public. These are the moments where courtroom hearings stop feeling procedural and start feeling deeply human. And honestly, this is where comment sections explode. Was the judge showing patience or losing empathy?
the class was canceled.
Who is the provider that you have?
His name is,
Grab me a phone number, because I'd like to call them right now.
I have a number for you, Judge.
And go ahead and put this on.
Oh, yeah. Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. Sir? I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, it allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a basic education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED concepts. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question. Depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though? Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
The judge's philosophy here is crystal clear. Compliance means complete compliance. Missed tests, camera issues, skipped check-ins. To the court, those aren't technicalities, they're red flags. Defense attorneys often argue these systems are imperfect and sometimes overly strict, but judges see repeated violations as proof that supervision isn't working. And once trust disappears in a courtroom, getting it back is incredibly difficult.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Why are you here?
Tengo corte hoy. I have court today.
No kidding.
De veras.
You don't say. ¿Por qué también estás aquí, señor Lazo?
Nomás porque tengo corte. Just because I have court.
You have a bond violation.
Violación de su fianza.
They are telling me that you are tampering with your scram device. Specifically, at 1 in the morning on October 15th.
Judge, with that, there's not very much information, so I'll not go much further into it. The tamper lasted a duration of 25 hours and 51 minutes, and alcohol was detected but could not be confirmed on that tamper as well.
Ese caso de manipulación también.
What they're telling me is that you tampered with the device for about 25 hours, and alcohol was detected during that time.
Yo ni siquiera he movido el aparato y el alcohol no he tomado nada.
I haven't even moved the device,
They're telling me.
Eso no es lo que me está indicando.
Sí, pero yo no he tomado nada,
I
nada
haven't
que he
drank
tomado.
anything.
Nada.
Nothing.
Y esto ni
They're telling me.
Ni lo he movido.
I haven't
No lo he movido
I
nada.
haven't moved it or anything.
That's not what they're telling me.
Eso no es lo que ellos me están
Pues
indicando.
no sé cómo, pero si yo no lo
I
he
don't know how I
movido.
haven't moved it.
Y ni he tomado
I
nada,
haven't
nada.
drank or anything.
Nada.
I unfortunately don't know how you tamper with the device, Mr. Lazo. But from what I understand, I want you to listen. You have somehow tampered with the device. The device is supposed to maintain a constant contact with your skin, and the device lost contact with your skin for 25 hours. Not only
I don't know why.
did it lose contact, but during that duration, they also tested alcohol.
Resultó en detector alcohol.
No he tomado alcohol, no sé por qué dice que alcohol, no he tomado nada. Desde que él me dijo que no tomara, no he tomado nada.
I haven't. She told me not to. I haven't drank anything. I don't know why.
You got?
¿Qué tiene usted?
Well, Judge,
Bueno, es
I mean, this is my client's word
la palabra de mi cliente
versus technology.
contra la tecnología.
Being that it's an imperfect world, I
Es un
would
mundo
request the
imperfecto
court
que
admonish
quiero
him
que lo
and
amoneste
make sure he gets the
y que
problem
se
fixed.
asegure de que
This final hearing perfectly captures the balancing act judges deal with every day. The defendant keeps pointing to one thing. I showed up to court. But the judge is focused on a bigger picture: violent history, probation status, bond violations, weapons allegations, and public safety risk. In bond court, judges aren't deciding guilt or innocence yet. They're asking one question above all else. If I let this person walk out today, what could happen next?
Sorry, Mr. Lazo. You tampered with the device for 25 hours. What am I supposed to do? Just let you go?
¿qué es lo que debería hacer? ¿Dejarlo ir?
No sé por qué, digo que siempre lo traigo igual, lo traigo donde
I don't
mismo.
know.
Y
I have
anda la
it the
pierna.
same every time. That's my skin.
Sí.
Judge, this is a second DWI constitute car accident. I need zero tolerance.
Yeah, I agree. Taking you in. I'm sorry. The bond is set now at, it's at $100. I'll set it at 5,001. Mr. Lazo, I need you to understand that we mean business. You can't tamper with the device for 25 hours. And they detect alcohol and think that good things are going to happen.
No alcohol, nada, nunca. Y esto siempre anda igual. No lo he movido.
The device tells me differently.
El aparato me está informando.
Goes with you.
Yo respeto.
I respect the things that you told me.